Good morning, everybody.
Good morning, DCJ.
We are starting late because of partly me, partly matters of the commission. Okay, are you ready? Let's start if you are ready.
We are ready,
Yes.
DCJ. DCJ,
Yes.
I thought I should just place on record that
Yes.
after your inquiry yesterday regarding local dairy companies and the contact that was made with them, our investigators have tried to work on that overnight.
Yes.
And have been able to find two documents. One, a report, a feasibility study. As soon as that comes to hand, a hard copy comes to hand, I will make sure that my colleague, Mr. Buthelezi, gets a copy of that document so that Mr. Thabethe can look at it. The second one is, I think, a couple of affidavits that deal with the same issue that appear to be in the bundle that the NPA had. Again, as soon as those documents are to hand, we will give Mr. Buthelezi a copy again so that Mr. Thabethe can deal with them.
Okay. No,
as I understand matters, Mr. Thabethe has in any event requested that he prepares a supplementary affidavit.
Yes.
He may wish to deal with those matters and whatever else in that affidavit.
Okay, no, that's fine.
In relation to the questions, Mr. Thabethe, good morning again.
Good morning.
We were yesterday going through your annexures, the annexures to your 2017 affidavit. Those are to be found in Exhibit HH10, Volume B. And that's the volume that starts with your 2017 affidavit and then has tabs where all the annexures ought to be.
Okay.
Are you good with that? Thank you. The DCJ will have to hear whether you are comfortable with what I've said or not.
Yeah. Chair, I wanted just to interject.
Yes.
If the chair would allow me to make a statement regarding the discussion we had yesterday.
Yes, okay.
Yeah, Chair, thank you very much. Maybe, Chair, I need to come back and maybe the statement that I have made might not have been appropriate regarding the issue of the media.
Yes.
I'm aware we made a debate yesterday regarding the media stopping the project.
Yes.
Yeah. What I'm saying, maybe it might not have been appropriate to say is the media that stopped the project.
Yes.
I think what is correct is that after the media article, then there were a lot of inquiries that were made, and during that period, maybe two things that happened. The one which I've referred yesterday, which led to Treasury doing an investigation, and the second one, which was the media inquiry that was also made to us, which also made them to be very reluctant to proceed because of the status of the project, because Paras is a multinational company.
Yes.
So they get worried about the media. So that is the issue, not necessarily meaning that is the media that stopped the project. I think that's what I want to correct.
To clarify. Okay, no, that's fine.
Thank you, Mr. Thabethe. We were dealing with Annexure 6, if you go to tab 6. And it's a report that we've actually dealt with largely in your previous evidence. I would just like you to deal with one small aspect that I don't believe we have touched on, and that you will find on page 316 under processing plant. The reason that I have a great interest as the evidence leader in the processing plant, of course, is because that's the money that Estina Paras was going to be providing.
That's correct.
Yes. Now, this state-of-the-art ISO 9001-2000 and HACCP certified facility that they were going to put up, you mention it in that report in the very last paragraph.
That's correct, Chair.
Can you, maybe we are not as technically inclined as you are, can you just explain what exactly they were supposed to put up? Because this is what you were expecting from them, this certified facility.
Yeah, Chair, why we had included that, those are the certification already they were having in their possessions. Those are the assessments that are being made, and then if a company meets those requirements, then they are given those certificates, which determine a certain level of compliance. So hence, then we refer to them. So it's a very technical kind of a certificate that is given that qualifies you to be able to issue, to be able to do processing at that level.
So it's a certificate that says that they have the capacity and capability to do processing at the level at which you had spec'd or specified the processing plant.
That's correct, Chair.
Thank you. It helps, because we will later on deal with what exactly they did then put up, and we'll come back to this. And again, we'll rely on your assessment and your knowledge on this. MPT 7, which is the next annexure, we have dealt with. Because of the presentation that we've just spoken about, the MPT, the Annexure 6, you then were able to secure resolution from the Provincial Cabinet. MPT 8, the next tab, Annexure 8, we have not received. This is the invitation letter that you would have received, I beg your pardon, you would have sent to the CEO of Paras. If you go to paragraph 12 of your affidavit, MPT 8 is dealt with that. So if you go to paragraph 12, just same document,
I'm sorry, are we going to his
same
affidavit?
File, his affidavit, same file, the same file, just the beginning, Chairman. And we go to page 247 of the same file. You mention here that you invited the CEO of Paras by way of a letter.
That's correct, Chair.
All I'm saying is we don't have that. I don't know if you want to add anything at all, but I'm saying I don't know if you still have a copy of that letter. It's not in the file.
Okay. Yes, Chair. It was when this affidavit was disposed, a copy of that letter was attached. It's one of those documents that are no longer in my possession, Chair.
That's fine. I don't think anything in particular turns on it, because we know that Mr. Kumar did come to South Africa. We've discussed that previously. Then 9, if you go to tab 9, that's the original project proposal by Estina, dated the 15th of May 2012. We have dealt with that in our previous hearings.
That's correct.
At the end of that, you have annexed the deviation, what we've been calling the deviation memo. Again, it's something we have dealt with. And that deviation memo would have been MPT 9. Okay? It's just at the end, after 8 comes 9.
Okay, thanks. Yes, it is.
And you'll find it there. We've dealt with that issue.
That's correct. Thanks.
We then move on to 10, which is the acceptance of the proposal. You have again dealt with that.
Okay.
In your evidence.
That's correct, Chair.
And the only point I want to confirm with you is that though you mention a partnership agreement in paragraph 2 of this letter, you have explained that you had not intended to establish a PPP. That's my understanding of your evidence.
If you can repeat again, Chair, I'm not...
Yes, okay.
What I'll actually do is read the sentence.
Okay, maybe let me say, she is saying she understands your evidence to be to the effect that you did not at any stage intend to establish a public-private partnership.
No, that's correct. That's correct.
And the only reason I asked for confirmation is because this paragraph 2 mentions a partnership agreement, just to make sure that we're on the same page. Thank you. Thank you, Chairman. We then go to 11, Annex 11. We did not receive that. It refers to the verification of account details. And this verification was supposed to be done by the Provincial Treasury. Again, I don't think much turns on that. We'll deal with matters relating to the Provincial Treasury when the Treasury witness or witnesses come in.
Okay.
MPT 12 is the agreement of the 7th of July. It's also called the agreement of the 5th of July. We've traversed much of the content of this agreement previously. There are just a couple of things that we hadn't looked at in that agreement, which I'd like you to just give a short explanation on. The first is, so if you go to 12, which is the agreement.
Yes, I'm there, Chair.
And you look at note 11.2 or clause 11.2. The heading there is intellectual ownership of intellectual property. And what I understand you to have agreed with Estina here is they must, and I underline the word must, return without delay to the department all materials in their possession which belong to the department. Most importantly is the next bit, regardless of whether or not such materials were originally supplied by the department to Estina. You are comfortable that?
Yeah, that's correct. Yes.
And there's no further explanation, that your understanding is the same. Estina had to give everything back to you.
Back to, yes.
Just to refresh my memory, we did deal with the agreement at quite some length earlier. But I do know that one of the issues I think I raised with you was the fact that this agreement was with Estina and not with Paras. Is that right?
That's correct.
Yes. My memory is not very clear now. By the way, did you say there was some agreement that the department had with Paras, a separate agreement, or was there just a letter?
Yeah, Chair, the agreement was between, the memorandum of understanding was between Estina and Paras.
Yes, but there was no agreement directly between Paras and the department.
No, Chair.
Yeah. There was some mention, I think, of some letter. Maybe it was a letter from Paras saying Estina would be their partner or something.
That's correct, Chair.
It was just a letter.
It was just a letter.
That was addressed to the department.
Yes, Chair.
Yes. Because I know that you said, I think, that from your point of view, your partnership was with Paras, and Estina was Paras' partner or agent or something. Yeah, is that right?
That's correct.
Yeah. But it would seem, and this is maybe a point that we did deal with before, but I just want to make sure. So it would seem that for all intents and purposes, in terms of records, the only entity that you had as a department, you had a partner, an agreement with, or a partnership with, was Estina,
That's
not
correct.
us.
That's correct.
That's correct, yeah. Okay.
Thank you, Chairman. We have dealt with 11. Can you please look at clause 12, financial control? And it says, this agreement is subject to the provisions of the Public Finance Management Act 1999. What had you intended here, Mr. Thabethe, if you could explain, because this is part of your agreement with Estina?
Yeah, Chair, this means that we will do all transactions in line with the PFMA. That's what it is saying.
You see, I asked the question because we have had discussions around transfer payments.
That's correct.
One. We've had discussions around how the PFMA gives effect to Section 217 of the Constitution. 2. We've had discussions around the Treasury regulations and how those two, of course, give effect ultimately to Section 217. My understanding of your evidence has been that the transfer payment, well, first, monies that were paid to Estina were transfer payments.
That's correct, Chair.
How were you going to account for those transfer payments within the framework of the Public Finance Management Act? That's all I'm asking you to explain. You may have done so before, but
Yes.
if you could just go over it.
Yes, Chair, transfer payment are in the PFMA.
Can you just take us to the particular portions that you think are directly relevant to this?
Yes, I may not be able to do it right now. Yeah, yes, no, that's fine. But your understanding is that there are provisions that deal with that.
Transfer payment, yes, Chair.
Yes. Yes, okay.
Can you then explain your essential understanding of how you would be holding Estina to account with the PFMA in your hand? And the reason I ask this is because I don't know if I should just bring it forward rather than leave it where it is. There's an Auditor General report that speaks to monitoring, etc. Can I deal with it where I've put it? It's somewhere towards the end.
Look, that's fine.
So I've understood from the Auditor General report, which we will look at,
Yes.
that there is a monitoring mechanism. I just thought you might be able to talk us through that monitoring mechanism.
Yes, Chair, what we had set up in the department for monitoring is that on a monthly basis, we're going to get monthly reports, monthly financial reports. And on a quarterly basis, we will also get quarterly reports. Now, the payment was paid in tranches, so that in any event you have a problem, you will then be able to say, wait, let's talk to this report before you proceed. So those mechanisms were in place. Now, on an annual basis, then the Auditor General also comes in, and they also go on site, they do their monitoring, and they do their assessment, and they issue a report in that regard. So monitoring mechanisms are in place in the department and also oversight outside the department.
Thank you. I know I can explore that further with different examples, but I understand what you're saying. Can we then look at clause 15.3? 15.3 is part of the termination set of clauses. And it's a bit of a tricky one when you look at the proviso, which is the last two lines of that paragraph. Maybe, again, it's useful, Chairman, just to read the whole provision in because it's going to come up again
That's fine.
in relation to the FDC. Mr. Thabethe, would you like to read that into the record, please?
Chair, are you referring to 1511?
No, sir. 15.3 on page 349.
Exhaustion of funds.
Correct.
It is also agreed that should funds no longer be available to pay for the execution of the project, the department may terminate this agreement in its own discretion or temporarily suspend all or part of the project by notice to Estina, who shall immediately make arrangement to stop the performance of the project and minimize further expenditure, provided that Estina shall hereupon be entitled to payment in full for the services delivered up to the date of termination or suspension.
So my question is, can you just clarify what the services delivered would be in the same sentence? So Estina shall be entitled to payment in full for the services delivered. What are those services?
Chair, there could be a range of services. There could be work done, paid for, but maybe the department did not pay for them. It could have been orders that would have been placed for delivery. It could have been work done. Hence the choice of services, so that you cover all areas that money was spent for, but not paid for by the department.
The reason I have been struggling with this since you started giving evidence is because we know that Estina was appointed as both an implementing agent and a management agent.
That's correct.
Now, nobody goes into an arrangement without there being some commercial value for them. And I've been grappling with how they were paid, either as implementing agent, was their fixed fee, or as the management agent. Can I maybe give you the example of FDC, which seems a little easier certainly for me,
Okay.
because with the FDC there appears to be a fixed contract price, and we'll talk about it later. I've assumed that that price was the payment for being an implementing agent. Then they subcontracted to HU Civils, who were being paid a separate amount. And I've assumed, all subject to what you will be telling us later, that that payment would then be for the managing agent part of things. So the FDC arrangement is a little easier for me to understand. I can't quite grasp the same differentiation between implementing agent and how they are paid here. Can you help me with that?
Yeah, Chair, the FDC one was very clear because they were required to do management. But in this instance, when you have a responsibility to set up a project, then when you set up a project, it means you are setting up the project. You cannot then claim management fee until you hand over the project. It means it is your responsibility to look after the assets until it comes to a stage when you say, now I'm done with the project, I'm handing it over. It's completed. Then beyond that, then you can charge management fee. If then you hand it over and you are not able to get the owner to receive it. But my understanding is that they shouldn't be claiming management fee other than direct cost.
For work done or for items procured?
Yes, direct cost then should be paid.
You see, Mr. Thabethe, I really just want to debate this for a bit. And I suppose I also have the shareholding structure in mind, where originally you had 49% going to Estina and 51% of the original Zena, if you remember, which was going to then become Ohuma Mobum.
That's correct.
Going to the beneficiaries.
That's correct.
So there, Estina would be a shareholder, and I can see the commercial benefit for them. As equity holders, they would be getting payment of some kind. That shareholding did not come into this agreement, did it?
No, Chair. You remember that after being advised by the state law advisors, we ended up with this agreement versus the first agreement. Now, this agreement was saying, first finish the project before the shareholding kicks in. Do it and finish it, and then you revert back to the shareholding structures.
So, I beg your pardon, were you going to continue?
No, I'm fine.
You're finished. So, what was in it for Estina here? You know, in Johannesburg, when I got here, it's an expression I learned. What's in it for me? What value was Estina going to get out of its association with this project? Were they happy just to assist and not get anything at all?
As an investor,
I don't know. Explain to me.
They would have a shareholding. Remember, the shares that we had agreed on will then be held by Estina. It means they were working as an investor.
But I thought you said that arrangement was not carried forward into the new July agreement.
Immediately. The advice, that's why the agreement was revised, so that it doesn't say outright that this is the shareholding. Finish the project, the construction, and once it's finished, Chair, then you transfer the whole asset into the shareholding structure. Now that shareholding structure is the one where everybody then will be holding shares. Because I'm sure we have looked at it on the letter that were sent by the state law advisors to advise us to say, at any given point, if the beneficiaries, whoever was there, would then decide, we are the owners, they would sell the shares even before you finish it. That's why the decision was say, finish the project and then transfer the entire project into that structure, which is a shareholding structure.
Now, when you started, this was supposed to be a 2-year project. Am I correct? When this started, it was supposed to be completed in about 2 years.
It's a 3-year project.
Well, 3-year project,
That's
okay.
correct.
So you are saying Estina was happy to wait until year 3 before it reaped any real benefits from the project, because that's when you would bring them into the shareholding.
That's correct, Chair.
Was that the arrangement?
That was my understanding, Chair.
Was that arrangement written anywhere?
Chair, I understood it that they signed this agreement that did not carry the wording of the first agreement, which means they understood this agreement when they entered and signed it.
Did you share the opinion of the state attorney with them and tell them why they would have to wait the 3 years before they became shareholders?
We did, Chair, when we submitted the second agreement. They were able to see that it will not be in it.
And the fact that they started putting money into the project is confirmation of the fact that I'm just trying to understand what you're saying, was confirmation to you that they understood the terms.
That's correct, Chair.
I'm going to explore with you a little later when we look at the monthly and the quarterly reports.
That's correct.
And a line item that says director's fees.
That's correct, Chair.
So we'll talk about those. You can think about it. And I'll show you the line item. And in the context of this discussion,
okay.
I will then ask you to explain what those director's fees might be.
All right, that's correct.
I've now understood 15.3 for services delivered, but strictly, and it's the next one that I wanted us to look at is invoices. I think somewhere here you talk about invoices must be presented on a regular basis. In fact, it was 13.5. We dealt with invoices. If you just go a page back.
Okay.
Yes. So those services delivered, you could easily assess because you would have an invoice.
Invoice, yes, that's
that
correct.
backed up the service that they were claiming for.
That's correct.
I'm good. If we then look at clause 19.2, under miscellaneous, it's on page 351. It reads, Estina shall not subcontract with any person for the carrying out of any of its obligations under this agreement without, in each case, the prior written consent of the department, which consent shall not be unreasonably withheld or delayed. That's an important clause.
Yeah, that's correct.
It's part of your monitoring, as I understand it.
That's correct, Chair.
Were you able to give effect to this clause? Were you able to put it into operation?
Chair, I'm thinking whether there was any discussion we held on subcontracting, because subcontracting means you're getting somebody to implement a portion on your behalf. It's different from appointing a contractor to do that. So I may not remember exactly whether we had anybody to be subcontracted.
You see, just by way of example, again, I will deal with it when we're dealing with what I call the financials.
Okay.
We are going to be talking about the feasibility study. You remember in phase 1, we dealt with October 2012, the feasibility study was conducted and completed. And they were able to show you that, and we have a feasibility study here in the bundle of documents.
That's good.
There are people who conducted that feasibility study.
Yes.
So I would want to know, and it's a group of people who are, for my recollection, not South African. So I would want to know from you whether 19.2 would have been applicable to those particular people conducting the feasibility study. So again, you may want to reflect on that, and when we get to the specific example, say to me, oh, I know these people. I signed off on them coming in. There are gateway invoices I'm going to be presenting to you. And you say, oh, I know these people. I signed off on them giving us giving the Estina certain items, even though they were subcontracted. Okay. So that's my interest in 19.2. I just want you to bear it in mind when we get to looking at those invoices.
That's
good. But the principle of the matter is, in terms of 19.2, subcontractors had to be vetted by the department. That's the principle that's recorded here. Implementation, Mr. Thabethe, is what we always come back to at the end of the day. So it will be implementation. How did we implement 19.2? Yeah. We then look at just one aspect. No, let's look at MPT 13. Which is the presentation you made today, AFF to DEF, the National Department. So it's 13, flag 13.
Are you moving away from the agreement?
I am, Chairman.
Or you are?
Yes.
Oh, okay, maybe before that. Mr. Thabethe, some of the questions that I might ask you might be questions that are linked to questions that we dealt with before, but it's been quite some time. You see, We talked a few minutes ago about the fact that the records of the department would only show Estina as being the department's partner in this project. Is that right?
Yeah, that's correct.
Yes, because the agreement was with Estina. Excuse me, and it did not say that Estina was entering into the agreement as an agent of Paras. You would know that it didn't say that, even though that might have some legal issues that maybe only lawyers would look at. So I don't want to be unfair to you, but it was Estina in terms of the agreement.
The agreement, that's correct.
Yes. Now I see that in terms of the agreement, clause 8.1.1, which is at page 345, the parties say Estina warrants that it is the counterpart of Paras. I pause to say whatever counterpart means. It is the counterpart of Paras and the sole provider for the services in the project. That seems to suggest to me, and I would like your comment, that seems to suggest to me that that clause meant that the department could not, if services that Estina was supposed to provide in terms of the agreement, could not go to somebody else. And in other words, you could not go to Paras and say, you know, you people are not providing the agreed services satisfactorily because you had signed an agreement that said Estina was the sole provider of those services. Paras would say, no, we might have some arrangement with Paras, but you can't sue us, so you can't come to us. Do you wish to comment on that?
Yeah, thank you, Chair. The understanding that I had on that statement was that we expected a certain level of deliverables in the project that should be certified by Paras to say we will be able to deliver what we had agreed on this project in terms of the standard. It would then be a problem if we bring somebody else and say construct 1, 2, 3, and then they come back and say, but that does not meet our standard. Then it becomes our problem. Hence we say, Estina, being a counterpart, will always be directed by Paras to say, to meet our standard, this is how it should be done. So they cannot come back and say, we've constructed this wrong because we did not understand how it should have been done. Hence we say then they should be the sole provider so that we should not have a misunderstanding.
Yes, but you see, the sole provider in terms of that clause of the services, as I understand it, you might have a different understanding. The sole provider is said to be Estina.
That's correct, Chair.
Yes. So what I'm putting to you is, it seems to me, therefore, that if anything went wrong with the services that Estina was supposed to provide to the department in terms of this project, the only people that you could legitimately, really complain to would be Estina, because it was Estina who was the sole provider. They were not the sole provider. They were not the provider or co-provider of the services with Paras. They were the sole provider of the services.
That's correct, Chair.
Yes, you accept that?
Yes, we accept, Chair.
Yes.
Chair, also in the earlier discussion we had,
yes,
was that this was done so for litigation purposes. Because
yes.
if we would have brought in Paras into the agreement, then international issues then kicks in.
Yes, but there's nothing wrong with international issues. I know you are not a lawyer, but if you need to involve international issues to protect yourself and to protect taxpayers' money, why not bring in those international issues? Because remember, we discussed this earlier within the context of the fact that you didn't ensure that there was proper checking of what Estina's business was. Maybe I'm inaccurate in putting it that way, but even its financial situation was not checked. And I think last time it was revealed that I think on the day on which they signed the agreement, or around the day when they signed the agreement, they had only about 16 rand in their bank account. So it's in that context, because, as I said previously, part of what one is looking at is to what extent was this project handled in a manner that protected taxpayers' money in the light of what we know happened. So this question that the sole provider of the services is Estina, and that's put in the agreement, means that, for example, to the extent that you might have difficulties with their services, you are stuck with them. And if you speak to Paras, they'll speak to you as a favor if they want to, but there is no agreement signed that compels them to come in if Estina fails to provide services. You understand?
I understand, Chair.
And you accept that?
Yeah, I accept, Chair.
Yes.
Because I had very limited knowledge
yes.
in drafting of agreement.
Yes, yes.
But I took it that it was fine.
Yes.
Yes,
Chair. And the state law advisors did were involved in the drafting of this agreement.
Yes, Chair. You remember that after the first agreement, the state lawyers requested that they assist in drafting of this one.
Of course, what the lawyer drafts depends also on what he or she is told by the client. And of course, what she or he is told by the client also depends on what questions he or she asks the client in terms of information. But it seems to me, and I just want you to comment, it seems to me that one of the things you ought to have said to them is, if we are going to enter into a contract with Estina, these are the protections that we need to have in the agreement, as far as I'm concerned. How you put them in the legal language might be something else, but this is what I want. And that you would have said, actually, as far as the department is concerned, it's Paras that is really our partner. Estina has an arrangement with Paras, but as far as we are concerned, it's Paras that we want to really partner with and hold liable in case something goes wrong. You understand that?
Yes, I agree with you, Chair. What was brought to my attention was that in the first agreement where we had brought in Paras was illegal because at my level I did not have a delegation to sign an agreement with an international partner. So that's why then it would be illegal to bring in Paras into the agreement. Hence then it was reduced to an agreement between the department and Estina.
Yes. What should have, the question that should have arisen, maybe I shouldn't put it like this, but there may be an argument that says the question that should have arisen in your mind and or the mind of the lawyers, of the state law advisors, is if the intention was to have Paras as a partner and there is not going to be an agreement with Paras, how do we make sure that the entity with whom we enter into an agreement meets the same standards that made us comfortable to select Paras as a partner? Let's look into those things, and only when we are satisfied about those things do we then go ahead and sign an agreement. Part of this might be linked to what we discussed already, but you might wish to say something.
No, Chair, I wouldn't want to add anything.
Yes, you are in agreement. Yes, okay, thank you.
Thank you, Chairman.
Oh, I think there is just one more question that I want to raise. I saw something quite strange here in clause 9.1 of the agreement, namely that Estina shall monitor its performance in the delivery of the project and shall implement appropriate monitoring and management procedures in respect of the project, including any reasonable monitoring procedure as the parties may from time to time agree. And then 9.2, on the notification of any failure or complaint regarding the quality of its performance, Estina shall attend to such notification with the agency appropriate to the nature of the failure or complaint. So the most obvious question about 9.1 is why was Estina to be the one to monitor its own performance? But maybe to be fair to you, I must point out that clause 9.4 has a clause about monitoring where it places the obligation on the department. It says the department shall monitor the performance of Estina and may at any time, in addition to the report in clause 3.3, request any further information. So on the one hand, there's a clause that says Estina will monitor its own performance, which I find strange. And then on the other, there is a clause that says the department shall monitor also. Are you able to throw any light on this?
Yeah, thanks, Chair. What we intended here was to say to Estina, you must have your own internal monitoring processes. There are instances in agriculture, where the department is responsible for monitoring compliance. Our responsibility is to monitor compliance. Now, in instances where...
When you say compliance, is that as opposed to performance?
As opposed to performance.
Yes, and you want to deal with the distinction?
Yeah, we want to deal with that so that we don't go there and monitor implementation and then we come and monitor compliance at the same time. So hence we have said, let the monitor do the monitoring of the implementation of the project, will come and monitor compliance. Because in terms of the Act, there are issues the department must monitor compliance on.
Which Act are you talking about?
The Agricultural Act, yes. So we have delegations to be responsible in the entire industry of agriculture to do monitoring on certain aspects. So those you don't want to mingle those two.
Yes.
And you do the job and you come back the following day and say, now I'm coming to monitor compliance. So we said, do your monitoring internally. We'll also do our monitoring in terms of your compliance.
Well, compliance would relate to what? To the performance of statutory obligations?
That's correct, Chair.
Yes.
You will have to have an environmental impact assessment. We will come and say, for you to be able to do this, do you have a PFMA, excuse me, Chair,
a certificate for doing it
that you have been given permission?
Yes.
For you to be drawing water from this dam,
have you got a license?
Do you have a license? Those things. We then come and do the monitoring.
Oh, so when you say the department was going to monitor compliance, those are the types of things you are talking about?
We're talking about, yes.
And in terms of the monitoring of Estina's performance of its obligations other than compliance with statutory requirements.
Yes.
It was going to monitor its own performance.
Yes, and remember they would then still give us a monthly report.
Yes.
Then over and above that, we will monitor the implementation and also monitor the compliance at the same time. So we'll do both. But they must give us a report of their own monitoring to say, this is what, because we don't want them at a particular stage to come and claim ignorance that we didn't know.
Yes.
Hence, if there is any failure that they pick, then they must be able to address it immediately.
Well, my concern with the idea or notion that a party to the agreement is given the obligation to monitor itself as opposed to, or is given the right to monitor itself, and that right is not being given to the other party, is that I don't understand why that would be so. I mean, if I employ you as somebody to do some work in my company, I monitor you, because I must satisfy myself that you are doing the job properly. And when I'm satisfied, it's fine. If I'm not satisfied, I raise issues with you. And I don't rely on, I don't give you the right to monitor yourself. See, and here it seems that the department was giving Estina the right to monitor its own performance. And that seems to me to suggest that if you try to monitor their performance, they would be entitled to say, hang on, you are in breach of the agreement. We are supposed to monitor ourselves. And that sounds strange to me.
Yeah, our understanding, maybe let me use the government scenario. Each department will have its own monitoring unit to monitor itself. over and above the external monitoring that comes in. So this you do so that you are able to pick challenges earlier yourselves. Now, that's what we were intending them to do. So
that's what you wanted to do?
Yes, they must then do monitoring internally. If there are problems, they are able to pick them early, so that whoever comes and do the monitoring, they are aware already, and they are able to say, this is how we're going to resolve it.
Well, I would imagine that anybody would do their, what you call internal monitoring, with or without any clause, because you want your own performance to be in accordance with your commitments in the agreement. You want to perform well. You don't want the other party to accuse you of failing to perform as required. But it may be that from your side, if you say, we want to see mechanisms that you put in place that will help you to detect as early as possible if there are problems in performance, that might be fine. The only question would be, that mustn't take away your right to monitor. And my concern is that from what you have said, it seems to me that clause 8.4, which seems to talk about the department's right to monitor, from what you say, maybe it could be relating to compliance, but I see that it does say performance, it doesn't say compliance. Did you see that?
Yes, Chair, we do both.
Yes.
Because by the Act, we have to do certain compliance.
Yes.
And there is work that we do that we also have to do compliance on. Some of them might not have been mandated by the Act.
Yes.
But we still have to do those monitoring.
But maybe I must take your evidence to amount to this, that although there are two clauses talking about monitoring performance, and the one says Estina will monitor its own performance, and the other one says the department shall monitor performance, what actually was sought to be done is the department will retain the overall right to monitor performance, but internally, Estina should also monitor its own performance so that maybe they can pick up things even before the department picks them up. It doesn't mean that the department wasn't going to monitor Estina's performance.
That's correct, Chair.
Okay, all right.
Thank you, Chair.
I think those were the two questions I wanted to, two areas on which I wanted to ask questions here.
Thank you, Chairman. It's given me the opportunity to just go back to two issues in the same agreement, with your leave.
Okay.
If we just very briefly go to page 338, it's still the agreement, but what I'm looking at is clause 1.2, page 338. 1.2 gives us the address of Estina. Block A, first floor, Grayston Ridge, 144 Catherine Street, Sandton. The question is, were you aware at the time that 144 Catherine Street, Sandton, that address is the address of a number of entities that are associated with the Gupta enterprises?
I may not have been aware at that time, Chair, although I have been to these offices. The relation during that time was not clear, but now I am aware, Chair.
And the relation between Estina and in particular Kamal Vasram and the Gupta enterprises, I'll put it as generally as that, was not clear at that time in 2012. Mr. Thabethe, then the last question on the agreement is clause 10, confidentiality. It's on page 346. When the National Treasury investigators from ENS tried to have a discussion with Mr. Kamal Vasram, who was the sole director at the time of Estina, when the ENS investigators and the National Treasury investigators tried to talk to Mr. Vasram about this agreement, about the relationship between Estina and the department, your department, Mr. Vasram refused to speak with them because he relied on this confidentiality clause, as I understand matters. He said at the time that he had to get permission from you.
Okay.
Do you recall him ever coming back to you to say to you, there are these particular people from National Treasury who want to speak to me? Can you release me from clause 10 of our agreement?
Chair, I have not received the request from Estina, although I remember discussing this with the investigators.
Yes, my junior has just pointed me to correspondence.
Yes.
From Mr. Vasram on this issue. And maybe for your information, it might be useful just to read what his response was.
Okay.
He is writing this letter to Amos Jacobs, and he copies Mr. Cele, who you know came to give evidence here on some of these matters. And he says, "We strongly object to the content of your mail, which seems to imply that we are deliberately not cooperating with you. At the outset, please note that we have already communicated to you that we do not consider it prudent to respond to your request in the absence of an approval from the department to do so. This is in line with the confidentiality clause in the agreement signed with the department, which can be verified with the department. Your continued insistence on breaking protocol appears to be motivated by an agenda that we do not understand, and under the circumstances, anything we say will probably be misconstrued. All the relevant documentation and information in relation to this project is available with the department, and if there are any gaps in the information, we are more than willing to assist you, provided that this is done with the active participation of department officials. This is an interdepartmental matter in which our participation in any form, if warranted, can only be initiated in the presence of department officials, or at the very least with their approval. Best regards, Kamal Vasram." So hence the question.
Yes, sir.
My understanding of the report of Mr. Cele and Co. was that you did not release Vasram from this confidentiality clause.
Chair, the investigation team did discuss the matter with me, requesting that I give them permission to investigate. The investigation that they were doing was the investigation of the department. We said, because they needed an exclusive investigation without the participation of the department, because there you're going to investigate a third party. Now, if you investigate a third party with the exclusion of the department, now that I can't give that permission. I would only give permission to do the investigation in the inclusion of the department. That's where we differed. I said, we have agreed to do the investigation because this investigation is being done to the department. if you proceed to do that investigation of Estina, inclusive of the department, I have no problem. That we had agreed, but they wanted an exclusive investigation of which I did not have a power to say, go and investigate a third party. It had to be limited to the application of the project. That is the situation that we had.
Well, the report, just to tidy this issue up,
yes.
The report that was prepared by those investigators is in the reports bundle, Chairman, at page 34. You may wish to look at it later, and this is bundle B, reports bundle
okay.
B. It's under witness interviews.
Do you think it would be necessary to look at it or not necessarily?
Chairman, if with your leave, I'll simply read this into the record.
That's fine, yeah.
Thank you. And it reads, if you'd like to, I don't mind waiting for you to find
yes,
it.
If you wish to look at it, it's fine. It's just for my purposes, yeah.
Reports bundle, and it should be B, little b.
Reports bundle.
Reports bundle, and it's in B. And the page is 34. And the paragraph is paragraph 2.3. It deals with witness interviews.
That's correct.
2.3.1, as you can see, Mr. Thabethe says, after our first interview with Mr. Thabethe, we approached Estina's director, Mr. Kamal Vasram, to discuss the project with him. Mr. Vasram is Estina's only director. Mr. Vasram would not agree to an interview with ENS and stated that Estina was bound to confidentiality in terms of the agreement signed with the department. We requested that Mr. Vasram produce the agreement giving rise to his duty of confidentiality. Mr. Vasram ignored our request, and we were not provided with a copy of the agreement. 2.3.2. At our second interview with Mr. Thabethe, we requested him to waive confidentiality and facilitate a meeting between ENS and Mr. Vasram. This is the important part, please, Mr. Thabethe. Mr. Thabethe refused to assist ENS and stated that we should conduct our own investigation without his assistance. Mr. Thabethe stated that he was in contact with Mr. Vasram and that he was aware that Mr. Vasram refused to meet with us. He was nevertheless unwilling to facilitate a meeting between ENS and Estina. Thereafter, ENS again requested an interview with Mr. Vasram, but he refused to attend an interview. As a result, we were not able to interview Mr. Vasram / Estina in this investigation to obtain their perspective and explanations regarding the project. The correspondence between ENS and Mr. Vasram is attached as Exhibit 18. That's the correspondence I read to you. What's your final comment maybe on this? I know we've dealt with it previously, but just having given it at least context in terms of the agreement.
Yes. Chair, this is exactly what I was explaining, that they needed an exclusive interview outside the department, which I could not do. We have agreed that we could do the interview of Estina with the department. So we'd bring them in and we will all sit and then they will do the interview. So we could facilitate, but they wanted an exclusive, them and Estina without the department. That was the difficulty that I had, that I could not give permission to them to go and do an investigation to a private party.
Why not?
Because I did not know what they would do. That's why we said we would send a lawyer of the department to go with them and sit with Estina.
But why would you need to send a lawyer of the department, Mr. Thabethe?
Chair, we had signed a disclosure agreement. They had said to us, as a private company, they have issues to protect which they would not want to be exposed. When we negotiated these things with Paras as international role play, so we did not know what would be those issues at stake. Hence, we said we would want that to happen, but then we wanted to make it in line with what National Treasury has requested us to do. National Treasury has requested that we want to do an investigation of the department in the implementation of Vrede, of which Estina is a party in the investigation. We don't have a problem with that.
Of course, Mr. Vasram, in that correspondence that I read to you, says if you gave approval, he was happy to talk.
That's correct.
To the investigators,
yes.
Number one. Number two, these are investigators who are doing work for National Treasury.
That's
you are
correct.
part of the same government.
That's correct.
Why did you have reservations about allowing National Treasury to speak to Estina, who at the end of the day was an implementing agent or was about to be an implementing agent, handling funds that essentially come from the same National Treasury?
No, I did not have a problem, Chair.
Well, there is something you have said you had a problem with, and you must tell me if my understanding is wrong. It seems that you had a problem with the investigators interviewing Estina without you or without anybody representing you there.
In the department, that's correct, Chair, because I would not want to be seen giving an investigator permission to investigate a private company.
No, Mr. Thabethe. Estina has an agreement with your department.
That's correct, Chair.
And it is going to benefit from taxpayers' money.
That's correct, Chair.
Treasury is there to look after the taxpayers' money.
That's correct, Chair.
They want to investigate. One would have expected that you would have said to them, oh, you want to speak to Estina, please, by all means, go there. And actually, if you want, I can pick up the phone and say, they must please make sure they meet with you.
Yes, Chair.
Whether I'm there or not, whether somebody from the department is there or not, is neither here nor there. Go and meet with them.
Yeah,
why didn't you say that? What was the problem with saying that?
I hear you, Chair. Maybe that time then there was a misunderstanding. Because my problem, I never had a problem to have the investigator speaking to him. My thinking was that they want permission from me.
Yes, but you... Well, they may or may not have wanted permission from you, but I don't see even why they thought it's necessary to get permission from you if they thought they needed permission, but that might be because of what I don't know in terms of how National Treasury operates and public service operates. But the fact of the matter is, Estina had an agreement with the department. In order for them to properly investigate the project, they had to speak to Estina. And actually, if Estina refused to speak to them, it seems to me it would have fallen upon you to say, you can't have an agreement with us being part of government and you refuse to talk to government, because Treasury is government when they're investigating. If that's your attitude, then maybe we were not going to continue with this agreement with you. If you enter into an agreement with part of government, you will be investigated. So what's your problem? So that's what I would have expected you to say to Estina if they resisted. So I don't know why you seemed to have a problem. I don't see why you had a problem and why you would even actually want to have a lawyer of the department to go there and be there when the investigators talk to Estina. Why?
Yeah. Chair, I hear you, but the thinking that I had that time was a different thinking. Now that we are speaking and the investigation is done, I hear your understanding.
You see the point.
I see the point.
Yes.
My problem was that also not being very clued with legal issues. I thought, because I had said to them, I don't see any problem in them doing an investigation directly with Estina without asking permission from me. The problem was that, why should the permission be asked from me? If the permission is asked from me, therefore, I would then need to have somebody to sit with them if I had given such a permission.
Well, from what Ms. Kabasha has read there, it seems to me that Estina was saying they were quite happy to be interviewed by the investigators if you gave permission. Did you ever get to know that that was their attitude?
No, Chair. The letter she's referring to had never been made available to us. His letter to the investigators.
Yes. Did, as far as you know, as far as you remember, did the investigators ever say to you, Estina is prepared to talk to us, but they want to know that you are permitting them to talk to us or permitting us to talk to them? Did the investigators ever say that to you?
In the meeting that we had, they requested me to waive the agreement so that they are able to go to speak to Estina. That's what they had asked.
And what did you understand the waiving of the agreement to refer to? Or is that the permission that you talk about?
Yes, to give them the permission to do the investigation.
Yes. And you did not do that?
Yes, because they were like the two issues, Chair. I did not see why they needed permission to do investigation. Because the agreement says they were not allowed to give information without the consent of the department.
That is Estina.
That is Estina.
Yes.
Now, if Estina would have then written to the department to say, we request permission from you, we would then have granted that permission.
I'm sorry, where in the agreement does it say they would need your permission? Are you able to?
Page 346, Chairman. 346.
Yes.
And it's the confidentiality clause, which says Estina shall not, during the term of this agreement and thereafter, without the prior written consent of the department, disclose any confidential information relating to the department and the project to anyone other than those persons who are connected to the department and or Estina and who are required or authorized to have access to such
I'm sorry. I think I missed this part. But then this appears to clearly say you must give permission.
That's correct, Chair.
So why did you say to the investigators, or at least you said to me earlier on, you didn't see why the investigators needed your permission
to do the investigation?
Yeah, so in the light of this clause, are you saying they did not need your permission?
Yeah, yes, the clause is saying, Chair, if they wanted permission from us to go and do the investigation, we said we don't have any problem for them to do the investigation, but then we would organize the meeting for them to come and do the investigation. But that's not what they wanted. They wanted an exclusive without the department.
Yeah, you see, what you refer to as an exclusive, you mean an exclusive interview with Estina, between the investigators and Estina, without the department?
Yes.
Yes, and why was that a problem?
Chair, like I explained, my understanding of what we are talking about in that time is different. I would have responded differently now.
Yes,
than how I had responded before.
Yes, yes. No, that I appreciate, but I want to understand your understanding at that time. What did you see as a problem at that time?
Yes.
in the light of this clause?
Yes, what I saw as a problem is me giving permission to investigate a private company.
Yes, but you knew that their request for permission arose from this clause, isn't it?
Yes, yes, Chair.
And in terms of this clause, Estina was prohibited from disclosing certain information to other people.
That's correct, Chair.
And obviously, the investigators, if they interviewed Estina, they would have wanted Estina to disclose certain information about the project to them.
Yes.
Yes, so they would need your permission then.
Yes. Chair, maybe I'm not, all I asked was that we bring Estina, the department, and National Treasury, and we sat and we discussed and we agree. We would have come up with a solution in that meeting to say, okay, proceed with the investigation. This is now all our understanding.
Yeah, but why do you want an understanding? They are investigating, and they want to interview Estina people.
Yes, Chair.
Why don't you give them permission? The clause says Estina must get permission from you in order to disclose certain information.
Yes, correct, Chair.
So why don't you give them?
I hear you, Chair. Like
Yes.
I say, the understanding I have now,
Would give the permission now.
give the permission now.
Yes.
But at that time,
Yes.
my thinking and my understanding of legal issues was different.
Yes, but you remember I said I understand that, I appreciate that in terms of now. I'm trying to understand what it is that you would have seen as a problem at that time, because it seems to me quite clear. It seems to me that any head of department who was really interested in National Treasury being satisfied that everything was in order would have said, oh yes, Estina, you have got my permission to disclose whatever they may ask you. These are not people who are coming from outside government. They are part of government.
I agree with you, Chair.
Yes.
At that time, my thinking was different from what, if you were to come to me now, I would have said, go and investigate.
Yes.
At that time, my understanding was that I'm afraid of giving permission for an investigation of a private company. That was my understanding. Then what I would say, Chair,
Yeah.
I made a mistake that time for not allowing them.
Yes, yes. But I do want you to, well, if that's all you are able to say in terms of what the basis was for your not being prepared to give permission, that's fine. But I'm looking at it because I don't know if when all evidence is heard, there might be a suggestion that it was more than that, you know. And I just want to make sure you get an opportunity to deal with it. But Ms. Kabashe might be having questions around the issue.
Chair, maybe just two questions. And really, Mr. Thabethe, they were not investigating the Estina as a private company. They were asking to investigate the project that you and Estina were partnering in. I'll use that word very loosely, partnering in. You're satisfied that that's all they were really asking to investigate?
That's correct, Chair.
The second thing is, I can't quite understand the nature of the confidential information that you sought to protect under this clause. Maybe that will help us understand your attitude. What is the nature of the confidential information you thought needed to be protected? And this is why you were refusing access to Estina without your being there.
Well, I see you look at me, Mr. Thabethe, and you are not sure whether to start answering.
Yeah.
And that's simply because I'm thinking that from your answer,
Yes.
well, maybe not really what I'm thinking about. You don't seem to have been concerned about the department. You seem to have been concerned about Estina.
Yeah, Chair.
But having said that,
Yes, Chair.
Answer the question that Mr. Wash has put to you. I'm just articulating this because you did realize that I seem to be wanting to say something. Yeah,
yes,
but now you know what I was thinking, but you can answer her question.
Yes. Chair, the question was that what I had in mind was that Paras through Estina would be doing products on the project. And they are the sole owners of those projects, or those products. They brand their name. Like any other company that has got intellectual property on certain products. Now, the problem comes when you give permission. To what extent are they going to request permission to expose some of those issues? Like when you get into the project, they do the construction in such a way. Hence, they said to us, when we do construction of the processing plant, we normally don't allow people to come and take pictures because we are exposing our intellectual property, so that people know how we achieve the production of this brand. Now, that information becomes very confidential because they were going to bring that information of that project in the construction phase, so that at the end it comes up with that particular brand of a product, which they've got a sole intellectual property in it. Nobody else will produce it that same way because it has the brand name of that product. Now, the understanding when we had discussed that was in line with saying the department becomes, we are giving you information that is exclusive in your construction. We wouldn't want that information to be exposed to everybody because in any event, then they will manufacture our product. They know how we do it. Now, that's the difficult. Hence, it's very difficult to say, it seems I was protecting Estina more than the department, but
yes.
This is what they had said to us. We are willing to come and assist you on those bases that you don't allow people to come and see how we deal with this product because it's our intellectual.
Yes,
Maybe
I see Mr. Washe certainly has more questions for you on the issue. I'm not surprised. Let's have the tea break and we'll resume. It's 20 past, we'll resume at 25 to 12. We adjourn.
All rise.
You may continue, Mr. Masha.
Thank you, Chairman. Mr. Thabethe, really just to tidy this up, just for my own understanding. One, I did not understand from reading the ENS, National Treasury report, that they wanted to go on a site visit, go to a factory, and investigate the types of products that were being manufactured. I would have thought that the ambit of National Treasury's inquiry would be, one, to get a copy of the agreement, which you apparently refused to give, and that would have helped them. Number two, to understand what funds had already been transferred to Estina. And once they understood what funds had been transferred, to understand what other conditional grants might have been agreed or might be proposed to be given to Estina to handle. And then just to monitor how these funds would be applied. That would have been my understanding as a public official, as an HOD, talking to colleagues, really. That was not your thinking at the time. Just give me.
Yeah, thanks, Chair. Chair, if that would have been the understanding at that time, there shouldn't have been a problem.
Then I just want to clear up, Mr. Thabethe, these emails that really give a different version to what you say. Because I'm not going to read all of them. I've read the most important one, it's just the one we read into the record. That one was dated the 5th of December, 2013. But before that, on the 1st of December, there was an email sent by, again, Ms. Jacobs to Mr. Vasram, saying, you have further not responded to my request to inform us on what basis you and or Estina and or Paras are claiming confidentiality. During our meeting with Mr. Thabethe on Friday, the 22nd of November, he informed ENS that he had discussed our request with you and that you were not willing to meet with ENS or to cooperate with this investigation. We therefore have no option but to deduce that you are not willing to cooperate with this investigation and the request from National Treasury. So the important thing there is we have spoken to Mr. Thabethe on the 22nd of November.
Just repeat, Ms. Kabashe, who that email was from and who it was addressed to.
So the date of the email, Chairman, it's on page 249 of the reports bundle, page 249. And it is an email dated the 1st of December.
Sorry. Please give me the reports bundle.
The reports bundle.
Yes,
it's bundle B.
Yes.
It will be small b. Yes. And page 249, please.
Yes, thank you.
They're filed back to front in a sense, Chairman, so I'll just help you navigate through those emails.
Yes, but you can just reiterate who it was from and who it was addressed to, and then he can respond. It
is from Jacobs, dated the 1st of December, to Vasram, and copied to Cele as a Barnard as well. And the title is clear, Vrede Integrated Dairy Project. So it was very clear to what they were trying to investigate.
Yes, but maybe before it, I just want to go back to the answer that Mr. Thabethe gave to your question before the break. Remember, at least part of what I was hoping would emerge is whether I was right in thinking that you seemed to be more concerned about protecting Estina than really the department. Now, you gave an answer and you talked about intellectual property and so on and so on. Am I right to say your concern was more with Estina than with the department in terms of confidentiality? If there was any concern on your part on confidentiality?
Not exactly, Chair, the way you're putting it. Mm-hmm. I did have a concern with Estina with regard to the intellectual property.
Yes.
But it is not. It does not mean that I had more concern about Estina than the department.
Okay, but let's clear this one at a time. As far as your refusal to give permission to the National Treasury investigators to interview Estina people without anybody from the department, your concern was with regard to the confidentiality of Estina's intellectual property. Is that right?
That's correct, Chair.
And then, was there any other concern that formed the basis of your unpreparedness to give the permission?
Chair, during the meeting that I had with them, they were not able to say to me, our interest goes up to this far. Because if that should have been the case, I shouldn't have had a problem.
You mean in the investigators?
The investigators, Chair.
What do you mean? What did you want them to say about their interest, as to how far their interest went? Exactly what is it that you wanted them to say?
Yes.
Is it about the scope of investigation?
Yes, Chair, the scope of investigation, if it would not have gone to an extent, because I told them that if it would not go to the extent, they should indicate to me that it would not go to the extent of dealing with issues of intellectual property, then there wouldn't have been a problem. But they did not want me to limit the investigation. It means they would have wanted to investigate any other thing, inclusive.
About the project? About
the project, which would have also included the issue of intellectual property.
Yes, no, I will talk about the intellectual, your concern about the confidentiality of the intellectual property in Estina. But as far as the department is concerned, what, if anything, was there that formed the basis of your unpreparedness to give permission? In other words, what interests of the department were you trying to protect against people from investigators from National Treasury in relation to in not wanting to give permission?
Chair, let me go back again. We had written a letter to the Director General of National Treasury. Mm. It was actually a letter of complaint. We had given information to the investigators. And that information we handed over to the investigators was in the weekend media.
Was in the weekend newspapers?
It was with the newspapers.
Yes.
We wrote a letter through the Director General of the province complaining to say, National Treasury has done investigation. Here is information we've given them, and that information was in the media on the weekend. Now, we complained to the DG at National in writing. We received a response to our communication to the DG, and the response that we are receiving comes from the investigator. The letter we wrote to the DG was responded by the investigator. Now, then we had a problem, because our understanding was that the DG would then say, how did this happen? You release information you gave to the investigator, and the information straight goes to the media. We had a problem with that. Hence, we wrote the letter and say, we have a problem, please assist us in dealing with this thing until the investigation has been completed. We cannot have a situation where investigator comes, collect information, and release it to the media. But we were not able to be assisted because we received a response from the investigator answering our letter we sent to the DG.
But how did that form a basis for you not being prepared to give permission to the investigators to go and see and interview the Estina people?
Why I'm giving this example, Chair, to say what then came to my mind, if then we would speak to them and they would say, no, we don't want you to limit us, including the issues of the intellectual property. It means they would have wanted to investigate any other thing in that relation. Now, that's where the problem came in, because if they would have agreed to say, no, we'll investigate implementation and all those things, your transfers, your payment and whatever, we're not going to get into the issues of the intellectual. That wouldn't have a problem, because those things are not mine. I can't give permission.
Well, you see, that's part of the problem. From what you have said, it seems to me that there really was nothing that formed, there was nothing relating to the department that formed the basis for your not wanting to give them permission. The only thing that seems to have formed the basis of your unpreparedness to give permission was your concern about confidentiality relating to the intellectual property of Estina. Now, I just want you to confirm whether my understanding of your evidence is correct.
That's correct.
It is correct.
It's correct.
Okay.
Yes.
Now, why would you be so concerned about any intellectual property of Estina when you were being requested to give permission, such as is contemplated in clause 10.1 of the agreement about confidentiality? Because if you gave permission and Estina thought you gave permission for the investigators to interview Estina people, one, that might have nothing to do with any intellectual property, therefore the investigation would go on. But two, even if there was something they wanted to talk about in relation to intellectual property or to see, Estina could protect interests by refusing. So why couldn't you say, look, as far as I'm concerned, I'm giving you permission. If Estina has any problem, you will deal with them.
Chair, I had raised it in the meeting with the investigators. That is my only limitation, which they were not willing to agree with.
What, the intellectual property?
The intellectual property.
But that's where I have a problem. Why you, being head of the department, were more concerned, actually, from what I think Ms. Tabashe read earlier on, it looks like you were more concerned about Estina's intellectual property than Estina itself, because it seems that Estina was saying they were prepared, saying to the investigators, they were prepared to meet with them if you would agree. They didn't seem to have the same concern that you had about confidentiality and in their intellectual property.
Chair, the issue is the issue of a condition.
What condition?
Because anybody who were to investigate and you agree with him, and then you come and you expose the issue of the intellectual property, then it becomes a problem, in my understanding, Chair.
Yes, but if Estina had a problem, they would raise the issue And also, you could pick up the phone and phone Estina and say, the investigators want me to give permission for them to interview you, and therefore I propose to give them the permission. Do you have any problem? You didn't do that, did you?
No, it has been done, and
Yes.
I've also said to the investigators that
Yes.
I've been in communication with Estina.
Yes.
With regard to this issue.
Yes.
And in our discussion with Estina,
Yes.
and this has been the problem.
Yes.
This one item has been the problem.
Yeah.
When I was discussing with Estina and when I was discussing with the investigators.
Yes. But from your side, you see, the permission that must come from you, as far as outsiders are concerned, I would imagine, is really more to protect information relating to the department. Because you, as in terms of the agreement, you could have seen whatever you needed to see from Estina. But as I understand it, I think that your permission was put in more to protect the department's information. And of course, I don't see why there would be a problem with National Treasury people seeing information of a government department as such. And of course, you haven't said that was your concern. You said it was with intellectual property. But I think that that's fine. We have reached a stage where we agree that your concern was with intellectual that you say that your concern was with intellectual property of Estina.
That's correct.
And did you know what intellectual property Estina had in relation to anything in the project?
Chair, that is the problem.
Yes, but you can't fight so much to protect something that you don't know. Did you know what intellectual property they had?
Chair, they had discussed with me the issue of the intellectual property. But those documents of the intellectual property were not. So I understood what was at stake in terms of the intellectual property, because they had to use some of those in the configuration of the project so that the output gets to what they are looking for. So I understood and I saw those documents which they were referring to.
Mr. Bashe.
Thank you, Chairman. You recall, Mr. Thabethe, that we showed you documents that indicated that Estina was a commercial company, IT company. It operated in that space.
That's correct.
I understood your evidence earlier to speak about production lines, specific products that you would have wanted ordered for the dairy farm.
That's correct.
Was that what you were communicating?
That's correct.
So, in fact, as the chairman has been asking you, it was Paras's intellectual property.
That's correct, Chair.
That you were concerned with,
yes.
Not Estina's.
Yes, it was Paras's intellectual property in the hands of Estina, because they were implementing. Chair,
Yes.
I don't know if I can explain.
Yes, explain, it's fine.
In a simple layman's language, a receipt for baking cookies, a particular cookies, you may not have until the person says, here is the receipt. Go and do it so that you are able to produce this. And these things are exclusively mine. Otherwise, if you don't use them the way they are, you're not going to achieve that product. Now, I'm just using that example.
Yeah, no, I think everybody understands that Mr. Bashe will continue with dealing with that.
Thank you, Chairman. Mr. Thabethe, I think I really don't want to belabor this very much further, because my understanding of the emails, and Chairman, I just commend them to you. They run from page 249
Yes.
through to page 251, and they will give further context to the same discussion, or
Yes.
at least the
Yes.
evidence is there.
Yes.
They are
Yes.
end of 2013
Yes.
discussion they reflect,
Yes.
and they reflect Mr. Thabethe's attitude.
Yes.
So I think I will just commend
Yeah.
these to you because Mr. Thabethe has spent quite a bit of time
Yes.
explaining his position.
Yes. I think maybe what you should nevertheless do is to put to him, if that is the case, that a reading of those emails, and you can specify them without going through each of them, a reading of those emails is not consistent with his version now on this point, if that is the position, so that he gets a chance to respond to that. If he wishes to look at those emails before he responds, that can be done, and we can, if necessary, he can look at that over the lunch break, and then after lunch he can answer that question if he needs to.
Thank you, Chairman.
Yes.
In fact, it boils down to this, Mr. Thabethe. The email dated the 1st of December 2013 to Mr. Vasram communicates clearly that you, Mr. Thabethe, informed ENS that you, Mr. Thabethe, had discussed ENS's request with Mr. Vasram, and that Mr. Vasram was not willing to meet ENS. That's what you communicated to ENS.
No, it's not correct, Chair.
Okay. So that's what that email dated the 1st of December communicates.
And that email is from who to whom?
It is from Jacobs to Vasram.
So Mr. Jacobs was confirming that according to Mr. Thabethe,
Yes,
Estina was unwilling to meet with them.
correct.
Okay. So, but you are saying that you never told anybody that Estina was unwilling to meet with the investigators?
No, I haven't, Chair. The bone of contention in my meeting with the investigator was them wanting to go and investigate without any reservation, which I discussed with them, and I told them the only issue which is a problem, unless they were confirming that I said they refuse to do investigation into the issues of intellectual property, then it would be correct.
But as far as you know, why would they be interested in intellectual property?
Chair.
Why would that really be of interest to National Treasury investigators about this project?
I'm looking at my senior counsel.
You are wondering whether he should stand up and object. He won't assist you to answer the question. He will leave it to you to answer the question. You know, some questions just need you.
Yeah, I hear you, Chair.
Yes.
Yeah,
you don't know.
I don't want to speculate, Chair.
Yes, no, don't speculate. But I'm trying to understand the thinking.
The answer that I would give you
would be speculation.
Would be a speculation.
Yes.
So that's why I say I don't want. That's why I'm saying I'm looking.
Yeah.
At
So
my
I guess
senior
that
counsel.
the correct answer then would be that you also don't know why intellectual property would be of interest to National Treasury investigators.
Yeah, Chair. why I'm afraid, yesterday I made a statement about the issue of the media.
Yes, yes.
I had to retract it this morning.
Yes.
And,
but you see, you don't have to be afraid of anything as long as you are telling the truth. If you make a mistake, you say, I made a mistake, I've thought about it, you know. So in other words, as long as you are honestly giving the answer that you believe to be true, if it turns out later to be mistaken or to be wrong, as long as it's what you believe honestly to be the truth, there's no problem.
Yeah, because you see, Chair, the other fear I have, I've seen statements being made at the commission, and thereafter people were sued. So, hence I'm saying I don't want to go to that area.
Yes.
A statement, and then I get into trouble.
Yes. Okay. All right. But
hence I'm saying I'm afraid to get there.
Yeah. But you accept that it seems that the only answer is the one I've suggested.
Yes.
Yeah. Okay. Thank you. Mr. Bashe.
Mr. Buthelezi would like to address you, Chair.
I think inspired to.
No, I think I'll let him like to raise, Chairman.
Yes.
Thank you, Chair.
Yes.
Mr. Thabethe's difficulty with regards to this question, because we did pursue it with him as well, is that there's a certain level of aversion towards making unsubstantiated statements which may in due course open him up to legal liability from parties outside these proceedings who may then go ahead and say, you said XYZ at the State Capture Commission, and we now want to sue you for those statements. So he says he has information that he has from his position as person having operated in the Department of Agriculture. And the nature of this information, and that was shared with him in confidence in the implementation of the project, was of interest to other persons outside the process.
Yes.
But he cannot make that as a statement of fact.
Yeah.
He may state it as an opinion or a thought that he has for himself. However, even in stating it as an opinion, he then renders himself liable by those third parties now pursuing him for having made such opinion on such a hearing. That's the only difficulty, Chair. So maybe between myself and Mr. Bashe, we could just confer for like 5 minutes so that we clarify what the position needs to be. Because ultimately he needs to assist the Commission get to the bottom of the issues and without any fear of reprisals from outside. And we need to then couch that information or those statements in such a way that they are helpful to the Commission, but they do not leave him vulnerable for civil liability outside this process.
Well, one, maybe we can leave it on the basis that maybe during the lunch break, the two of you can
Thank you, Chair.
Talk to each other about it, and then when I come back after lunch, if we need to revisit the issue, we can look at that.
Yes, Chair.
Having said that, I just want to say that the question was I asked the question because it didn't seem to me that one would necessarily think about National Treasury investigators being concerned about intellectual property. And if I'm correct in that thinking, then there may be a question as to why the approach taken wasn't that you people, you go there, do as much as you can, and Estina will if Estina raises problems about anything, let's deal with it at that stage and try and solve it at that stage. But maybe the two of you can confer over lunch, and then, depending on the need, we can then revisit it after lunch.
Thank you, Chair.
Yeah.
If I may add an additional point. The issue in this instance wasn't so much National Treasury itself. But what had emerged was that National Treasury had outsourced to an independent outside investigator to conduct the investigation on behalf of National Treasury. Now, that now places it in the realm of an independent third party doing the work for National Treasury itself. And if that information is now sitting with the independent third party, it's no longer in the exclusive control of National Treasury.
Yes, well, except that National Treasury can put conditions to the appointment of a third party to say, because you'll be doing this for us, these are the limitations, so that that third party is in exactly the same position as would be somebody from National Treasury doing the same thing.
Indeed, so, Chair.
Yeah.
But I accept your point, Chair.
Yes.
We will take it up during the lunch break.
Okay, no,
Thank you
that's
so much.
fine. Thank you. Mr. Bash.
Thank you, Chairman. I just want to put the second proposition. So the first
Yes.
one related to the email of the 1st of December 2013, Mr. Thabethe, and what is recorded here is that you said that Mr. Vasram was not willing to speak to the investigators. You have denied this.
That's
The
correct.
second proposition is there's the email dated the 5th of December from Mr. Vasram to the investigator, Ms. Jacobs. And in this, he says, the very last line is, at the very least, if you approve, this is his attitude. If the department approves, he's happy to speak to the investigators. What's your comment on that?
That's correct, Chair. The indication here is that if we would say proceed, then they would do so. After having cleared what we have been told is their concern, because they had communicated to us their concern.
I'm sorry. The last one, it's an email from whom to whom?
It is an email, Chairman, from Mr. Vasram.
Yes.
It's on page 249.
Yes.
It's dated the 5th of December.
Yes.
It's to Ms. Jacobs,
Yes.
and it's copied again to Mr. Cele and Mr. Barnard.
Yes.
And Mr. Vasram writes that, and I'm just reading the last sentence, which is the most relevant,
Yes.
that this is an interdepartmental matter in which our participation in any form, if warranted, can only be initiated in the presence of department officials or at the very least with their approval.
Yes.
And it's the very last few
Yes,
words.
yes.
He was prepared to talk to them
Yes.
as long as Mr. Thabethe approved
Yes.
the interview.
Do you accept, Mr. Thabethe, that at least as at 24 December 2013, Estina, Mr. Vasram, were prepared to speak to the investigators? I'm tempted to say about anything relating to the project, as long as at least they knew that you had no problem. Do you accept that that was factually the position?
Chair, that was correct.
Yes.
Because in the discussion between me and him, hence he has put it down, was that for us to be able to have a clear understanding of what they would ask him, he said if the department was there, so that you make sure when they go to the area where we are not comfortable, you would be able to assist us. That we said it's fine. If I were to give an approval, I would have then requested the investigator to say to me, we are not interested in the intellectual property. We therefore give you a permission to proceed with the investigation. So those were the two things, Chair.
But he seems not to be concerned about that. All he seems to be wanting is, if there is no official from the department at the interview,
yes,
at least you should be able to say you are okay with there being no official from the department, and they can continue an interview and go into the interview. He doesn't say, as I understand, he doesn't say we are happy to we are happy to discuss with you everything except intellectual property.
Yeah. Chair,
I hope I'm right, Mr. Bash, in terms of what they say, Estina, that they don't seem to say we are happy to discuss anything with investigators other than intellectual property. They don't seem to say that.
They don't speak to the issue of intellectual property at all. They simply speak to the approval, which is what Clause 10 deals with, if you give us permission.
So they don't raise that issue at all. You were concerned about it, but they, based on this, it's not their concern. They are concerned. And they are not saying, they are not, there's nothing here that shows that they want you to refuse permission. There seems to be nothing suggesting that they want you to refuse permission. They just want you to make up your mind.
Yeah. Chair, I'm responding on the basis of my communication with Basra.
Yes.
Hence, I'm commenting on this, not directly as it is.
Yeah.
Because it was their communication. My input into it is what we had agreed on.
Okay.
I suppose my closing comment is you actually went with the ENS investigators to the farm in October 2013. That's correct, isn't it?
Yeah, I'm trying to think. I can't remember, Chair.
Yes, okay.
The date is not important. The important fact is you accompanied them to the Vrede dairy farm on a site visit.
Do you have any recollection? You might not recall.
I'm not recalling, Chair.
Okay. You might be able to help him.
Page 48 of the reports bundle. Hopefully it's the same one you have. It should be the same, but just go to page 48, paginated page 48.
Reports bundle.
B. Reports bundle B. That's where the emails
And
were.
where the email was, the one you were having.
With
the one
emails.
in front of you, that has the email that we were looking at just now. Yeah, page 48.
Page 48. No, Chair, the one I'm looking at is HH10B.
No. That is, you are trying to find the reports bundle,
Okay.
small
Yes,
b.
I've got it.
Thank you.
Page 14.
No, 48.
Okay, I've got it.
And it's just that very first line at clause or paragraph 6.1.1. In October 2013, ENS visited the Vrede Dairy Project site, accompanied by Mr. Thabethe. You can't recall that visit. Very first, 6.1.1.
I'm thinking, Chair, I'm not denying it, but
You can't remember.
Yeah, I can't remember. I might have been there because I've been there with a number of people.
Yes. So it's possible
doing
that
investigation, but I can't remember exactly
with them.
How many people? There were so many people because I think this is the fourth investigation. So there were many instances I went there. So I can't remember. I might have been there.
Well, I don't think that the investigators would put a fact into a report they have prepared for National Treasury if that fact, especially something like going on a site visit, would not be verifiable or correct. If you go to page 51 of the same report, they actually conclude, 5151, that it was clear that progress was being made on the construction of buildings and that a number of cows had been purchased. But they go on to say, at 6.2.2, that ENS was not provided with access to the financial records of the project. And as a result, we were not able to comment on whether the project is progressing. To date, the department has only invested the funds it was required to invest in the 2012-2013 financial year. No further payments have been made to our knowledge. It is therefore likely that the project may be experiencing cash flow difficulties. And I read this only to indicate that I would have thought that this really is what National Treasury's interest is. How are funds that come from the fiscus being spent on this project? That would have been their core mission. I don't know if you want to comment on that.
Yeah, Chair, I don't know why they would have struggled in the department to get that information, because I had given them access to the department supply chain, which had all these documents in terms of payments and what payments had been done. So they had been there, they were able to access this information. So I read that they were not able to access information. I don't agree that they would not have had access to this information, because that formed the basis of the investigation. And they were given access to the department supply chain to be able to do so.
Mr. Thabethe, if my recollection, my memory serves me well, when we postponed this matter, we gave you a file that had the ENS report.
That's correct.
Because you had indicated that you did not really have access to it. You may want to read it again and look at some of the issues that they raise and deal with those, because I think you are at complete opposite ends of the spectrum in relation to what was provided, what permissions were granted or not granted, and what progress this investigation could make in the given circumstances.
Yeah. Chair, they had never complained about me refusing them access to the department. So they had access to whatever they wanted to investigate. What I had said before was that this report came to my attention for the first time in the court's records. I was never given an opportunity to respond to the report. I would have, because when a report is being issued, normally they will then give you a copy and say, this is the findings. Do you have any comment to make on this report? Now, I was never given that opportunity to do so. I would have corrected a lot of things in the report which might not have been properly done if they would have given me a draft, say, this is our outcome. We can't find that, we can't find that, we can't find that in the report. Either to correct or to make available that information which they are saying they are not able to get. Now, I saw this report when the first draft that I had also made available to the commission, I got this report was issued from the legislature. And I had a copy that was given to me at the legislature, which was talking to these issues before they released the report. Now, then the question kicks in, Chair, where Council says, But how was this working? Everybody else had a copy of the report except the department. And when I went to the legislature, I went to answer questions on the basis of a report that I was not provided. And then that's what I said, and I was given a copy by the legislature. And when they gave me a copy, they wrote on top of the copy that I cannot use it for any other purpose other than responding to the questions of the legislature, which is what I did. Now, that report which I got versus this report that was in court did not bear the same date. But I had used the report at the legislature for responding to their question. Now, my question has always been, and if you also read the public protector's reports, it comes out very clear in a number of areas that I did not have the copy of the report. It seems they had a copy of the report because they were asking me questions about it, but I did not have, and they, from their side, they never gave me a copy of the report to be able to talk to the report until I then went to court, and then I got the copy of the report. So that has been my problem with regard to this report. I would have made my inputs before the report would have been released.
Chairman, I don't think I want to pursue this particular point.
That's fine.
Any further.
That's fine.
I'd like to move on to the next aspects. Mr. Thabethe, we are back at your annexures to the 2017 affidavit, and so that is HHB. Yes, you've got the right document there.
That's correct.
If you look at flag number 1313, that is a report, a presentation actually that you made to the National Office, the Department of Agriculture and Fisheries, Forestry and Fisheries. Is that correct?
That's correct, Chair.
And when would you have made this presentation? Can you recall?
I'm trying to recall, say I may not remember the exact date.
Just the period, because my assumption is that the purpose was to get funding, conditional funding.
That's correct, Chair.
So just give us the ballpark.
I think, Chair, it could have been, now I don't want to make a mistake because between going to the provincial Executive Council, I'm not sure whether it was before or after. I think it could have been before, because when I went to the Executive Council, I was then able to say what is possible from us. I think it was during that time for us to make sure and ascertain. But I'm just trying to think. I can't recall properly. It could have been after the Executive Council says to us, go and look for money. Then we went also to National to say, we have this proposal. And
I would suggest that it's probably the latter, because if you go and look at page 373 and 374, it would appear, especially at 374, that you are setting out the additional funding required in the current financial year.
Okay. Yeah, I think so, Chair. It could have been after I have received approval to then go to National to present this project to source funding.
What I found interesting was that the feasibility study substantially reflects the same information that's in this presentation. Now, the feasibility study was completed at the end of October 2012.
That's correct.
My question is, which document informed the content of the other? Did the feasibility study inform the content of this document, or did this document possibly inform the content of the feasibility study?
Chair, there are two documents. There is a pre-feasibility study that was done, which was short and concise, and then there was then the detailed feasibility study. So the initial feasibility study also went into the bigger feasibility study.
Now, just to get absolute clarity on this, the bigger feasibility study is the one that you signed off on when you signed off on the phase 1 milestones that had been completed. Is that correct?
Yeah. Chair, I'm trying to bring it back to perspective again.
Yes.
When we went to the Executive Council and they gave us the first tranche of payment, part of that money was also to do that feasibility study. Hence then when we signed off, we then also got that money then to go and do the detailed feasibility study. But then the pre-feasibility study was already done, which was positive at that time. But we wanted the detailed one for us to be able to say, yes, indeed.
I'm sorry, I just want to understand your answer. Are you saying the first 30 million that was paid was for purposes of doing the pre-feasibility study or the larger piece of work?
Chair, it was supposed to do the larger.
Mm-hmm.
That's correct.
And that's why the larger was part of phase 1?
That's correct.
Because that would be consistent with what you've said before, that your understanding of the 30 million
that's correct.
was it was supposed to cover phase 1.
Yes.
Okay. Can I very briefly take you through Mr. Davi Mare's report, which we've also furnished you with?
That's correct.
I'm not wrong. And I know you've given us 1 or 2 comments before, so I'm just going to go through this very quickly. The bundle
Please
you need,
remind me where to find it.
the bundle, Chairman, is Reports Bundle B.
Yes, what page?
And the first page will be page 288.
It doesn't look like, but no, I think my 288.
It's para 1.4, Chairman. Page 1, the cover page is
Report bundle B,
Report Bundle B, Chairman.
and page 288.
The cover page is page 284. The cover page
284. Okay,
would be 284.
okay.
285.
I think it's the same
one.
thing. It's just that I thought you said the first page would be 288. Maybe you meant the first page to which you want to talk.
I see.
Yeah.
It is, in fact, it's paragraph 1.4. That's where I want to start.
Oh, yeah, okay.
And here he comments on location, essentially. And the essential point made about location was that this was a rather arid part of the in dairy milk cow farming territory. He speaks to the coast, the Midlands really, being perfect for dairy farming. And then he goes into the number of producers who have shut down. I don't know, I know you've read the document. You may just want to give us a comment on what Mr. Mare's issues are with regard to local.
Thank you, Chair. Maybe I'm seeing it differently
Yes.
than the way he sees it. Before I comment to that, I want us to look at his table. Just
Yes.
below that.
At
1.4 under background, table number 1.
yes.
Now, his table number 1 is it's giving months a number of milk producers per province.
Yes. In different years.
In different years. Now, I take it January 2006. The Free State had the highest number of milk producers.
1,067.
1,006. Which we have raised in our report.
I'm
That
sorry, did you say the same
No.
number?
1,067 was correct.
1,067.
Yes.
Sorry,
Oh,
Chair.
I thought you said 1,006.
Sorry, Chair.
Yeah, okay.
1,067. Now, if you look at his report, you'll see how quick the decline is, specifically in the Free State. It will mean dairy farming was doing well in the Free State, irrespective of the statement that is saying it's inland.
You say declining means it was doing well.
The number, it was doing well, and then we started
Initially.
Initially.
Yeah,
And then we started to
2006
see
it
the
was.
decline.
In 2006, there was a great number of milk producers in the Free State.
Yes.
Yeah.
Then it started going down.
Yes.
On top of the Free State,
Before you do that, by January 2012, the number of milk producers in the Free State, in terms of that information there, had gone down, had decreased by something in the region of 2/3.
by almost half, Chair. By almost half.
Oh, no, I think you are right. I was looking at 322, which is for KwaZulu-Natal.
Yes.
By half, yeah. By
half.
almost half, yeah. You are right, yeah.
Yes.
Of course, Mr. Thabethe, Mr. Maria does say in that first paragraph that this decline is a result of higher production in the pasture-based areas or the coastal areas. The cost of milk production inland provinces is a key factor due to the increase in maize prices and other input costs. So he puts this decline to environmental factors. I'm calling them that.
Yeah.
I just wanted you to factor that into your answer, or to take it into consideration.
Yes, Chair. I just don't want to forget to answer your first
Earlier question, yeah.
Yes. Because he is saying the Free State is an area where you would not do dairy. That's my understanding. Why did you choose the Free State?
Today, yeah.
As Free State? Because we are in the Free State. We can't choose another province to do dairy other than the Free State. Nationally, we would do it differently. But we had an understanding that the Eastern Free State is the highest rainfall area. The arid part of the Free State is the west and the southern part towards Harib. That is the arid. Now, the Eastern Free State has a very high rainfall area. Hence, we've got fruit production there, we've got dairy concentration and all that. So I would not agree with him that in the Free State you would not do dairy.
Well, do you accept his figures that between January 2006 and January 2012, in 6 years, if I'm correct, the situation in the Free State which I take to refer to the whole of the
Correct.
The situation was that the number of milk producers went down by half over 6 years. Do you accept that statement?
I accept that statement, Chair.
Yes.
Yes, but I want to talk to that statement also to say,
yes,
this decline was a national decline. Mm-hmm. It was not only the decline of the Free State. So the entire country, in terms of dairy production, we were declining. Mm-hmm. Not on the basis of arid, but on the basis of cost to do dairy. Mm. There was the cost of doing dairy versus the return on the price of milk. Farmers were not making it, hence they were leaving dairy. Now, that has been our opening statement when we started Vrede Dairy. We say we want to deal with that issue because we saw in the Free State the rate at which the number of dairy farmers were declining were very high. So we had to do something. So I agree with his statement, his figures, but the statement he is mentioning here, it's a country statement, it's not a statement specific to the Free State. Because everybody has been declining. So that decline cannot only accorded to the Free State province. Because it was the true statement for each province. All provinces declined.
Yes, continue. I'm trying to give you the opportunity, Mr. Thabethe, to deal with the issues, including the second question.
Yes, Chair, I've responded to the first question.
Yes, yeah.
To say this is what is my understanding,
yes,
and his figures are correct.
Yeah, okay.
His figures are correct.
His figures are correct in the table,
but the reasoning?
The reasoning behind it is the one I do not agree with.
Continue.
I'm not saying the Free State did not decline, but
yeah,
it is not only the Free State that declined. So it cannot be accorded to the Free State.
But you admit that by 2013, there had been a substantial decline.
Decline, yes.
In the Free State.
In the Free State, but we had provinces that declined more than the Free State.
Yes.
If you look at the last column on the right, in terms of the percentage, the Free State had declined by 57, and then if you look further down, there are other provinces that declined more than 57. So the issues at play here, there were many issues. They cannot be accorded to one area to say this exactly the reason. So it's a number of issues.
Well, I would imagine that you wouldn't go into a business sector which had effectively driven away 50% of businesses unless you had a solution for the problem that drove those businesses away. What was your solution? What was driving them away, and what was your solution?
That's correct, Chair. Further on in the report, he's saying the only reason why in other countries dairy farming is a success is because of government involvement. In his report, he says because government is assisting the farmers. He normally calls it in the United States and Europe a tariff. In South Africa, we call it a grant. That way we assist the farmers. The problem was that you had farms that had infrastructure for dairy. The infrastructure is inexistent. And those farmers are pulling out, they say, we can't make it. The cost becomes too expensive. So you needed an intervention of government to come in and say, we will make it easier for you by bringing in a grant, because this project was going to be built with a grant from government, which is not going to be costly for the farmer to be able to go back to dairy farming, because the distance for the supply will be closer and they will be able to focus in the production, and then the cost element is then going to be reduced. Now, that was the thinking that made us to go back to say we need to assist. We can't allow the decline of dairy in the Free State, being the 4th largest producer of milk in the country. I agree with him, the coastal provinces were doing much better because of environmental factors. But the Free State did very well, because in all the inland provinces, I would say in the inland provinces it was number 1. So we wouldn't say we wouldn't do it there because we are inland. Environmental issues are not so good for us, when before that we had proved that it can be done.
Yes, I'm just trying to move on.
Yes, well, let's talk about that, Mr. Thabethe. If you are into milk producing as a business person, and on your own, I know that you are going to fail, because I know about 500 other milk producers have failed over the past 6 years in the same province. And it seems that the reason you failed is because you didn't produce enough, or the business required you to spend too much on it than you were getting in. And now I say, well, I don't like this idea that you are failing. I want to assist you. I'll put in money.
That's correct.
Okay. One of the questions that must cross my mind is, if I look at what I may have to put in, the money that I may have to put in to assist you, I must also look at what you will get out of the business and see whether it will be worth it. Because it wouldn't make sense if on your own, if you ran the business on your own, you were going to go under. I come in, I put in a lot of money, and you still go under. It might also not make sense, even if you are not going to go under once I've put in my money, if nevertheless whatever you will get maybe might just be enough for you to float. You know. Now the question is, was there a study that looked at that to say, what will these farmers get out of this, realistically speaking? And when we look at what the department will put in for X number of farmers and what they will get out, will it be worthwhile? Now we know that over 3 years, you were going to put in about over 300 million rand. That's a lot of money.
That's good.
Did you know what was realistically expected they would get out of the business over the 3 years?
Yeah, thank you, Chair. We had looked at that.
Mm-hmm.
The National Agricultural Marketing Council had done a study. And the study was indicating if this rate of decline of dairy farmers in the country would proceed the way it was proceeding, it would mean that the country must then come with a plan of how to import milk, because our own dairy farmers were not making it. It means that's the direction, because if you don't come in with an intervention strategy, it means you'll end up with all the small dairy farmers going out, only the large will remain. So the report was saying something needed to be done. We cannot allow it to disappear because it's a food security issue now. If you look at the country, we cannot rely on milk that we are importing. It is a problem, but we have to do something to make sure that we still have producers of milk in the country. Otherwise, we must decide we're going to import meat from. We have failed producing milk, we are leaving it. And this intervention, when we looked at this, we thought the issues that were being raised to be the cause of the decline could be addressed. If you look specifically at the Free State, I think we had discussed this also earlier, Chair, that people that are selling milk are price takers. Somebody comes and say, I can buy your liter of milk for so much. Take it or leave it. It means you cannot decide how much you want to sell your milk. They tell you. You are a price taker. They tell you we can buy so much of your liter of milk. If you don't take that price, you are out of the market. That's what we wanted to address. Because for the Free State producers of milk, it was very expensive. One of the elements that was making it very expensive was the cost of transport. Because that cost of transport to come and collect your milk, it is actually charged on you, the seller, that it costed me to send a truck to come and collect your milk. Therefore, I can't buy your milk at that price. Hence then, Chair, you'll remember I said, that's why then we reverted on the model of Paras, because Paras was the one sending the trucks, collecting the milk, bringing it into the processing facility. Hence, we're saying this processing facility will solve the problem of most of the farmers, because the milk will be collected closer, and the price will be much better, because the facility, nobody needs to pay for the facility because government has paid for the facility. Because if a private person comes and put up the facility or have borrowed money to the bank, he must make sure he makes enough money to go and pay for the facility if the farmer has done that. But in this instance, nobody owes it because government has invested into the facility for all farmers to benefit into it. Now, that was our first model to say, let's implement this one, we believe it will succeed. And then we'll address the decline of the farmers, because the prices will now be better because of the investment of government into that sector.
But, well, you see, if the real problem was transport, and if the transport cost could be solved by having a government truck going around, that is much more less than the 300 million rand that you'd use for the first three years, and obviously you are going to still use many more millions after. So why don't you just do exactly that? To say this is where we will assist you because this is where the problem is.
Yeah, Chair, it's not only that. I've
what
just
is the other one?
Put that one forward. Remember, in this model, the farmers were also shareholders into the factory. This is not privately owned.
Yes, but let's go back to what the situation was before you came with the project.
Yes.
You see there is a problem.
Yes.
The number of milk producers is going down drastically.
Yes.
And you say one of the problems is their prices can't be, are affected by the transport costs.
Yes.
And if government can take care of the transport costs that could go a certain long way.
Yes.
What were the others?
But over and above that, Chair, also being a shareholder, because it means per liter of milk, you are getting more than only selling the milk to the processing. Also a participator in the value chain. You are not only selling your milk to the private sector and that's it. It means your beneficiary.
I mean the farmer.
The farmer, yes.
Yes, but what I'm talking about is, why don't you say, okay, here identify farmers who are milk producers and say, we understand that this is where the problem lies. That's where we'll come in. You'll continue as normal, but we'll give you a helping hand in relation to costs. But otherwise you continue, and then you should be able to sell more of your milk, because now you don't have to worry about transport costs. Government will take care of those.
It's not enough, Chair.
Yes, what were the other challenges? If that was solved in that way.
Yes, that's why I'm saying, Chair, if you are if you are part of ownership of the company that do processing, you get more money than only being provided with the transport. So it becomes a lucrative business to go into. Yes. Because you also get money in the processing, which when you are only selling, you are not beneficiary to it. So it will then encourage even more farmers to get into it, because you don't only get the money for your milk and transport it for free, but you also get money after your milk has been processed.
But that was the only other one, or the other issues? Costs and being shareholder?
Cost and being shareholder.
Transport costs and being shareholder.
Yeah, that was the part that will then assist them.
Yes.
And hence they will then have enough money to be able to deal with the issue of the production cost.
Okay.
Mr. Thabethe, of course, the issue of water, I'm still dealing with the location.
That's correct.
And then you talked about rainfall patterns, etc., that it's not arid. Water is critical to running a dairy farm. You will agree with that?
Yeah. Chair, water is critical, but the Eastern Free State is not arid. You don't have a problem of rainfall. That will be a concern in an arid area.
That's a view that you hold, Mr. Thabethe. If we turn to page 293 of the same document, it's 293. I just want us to look at that feasibility study and his comment regarding water, which is right at the bottom of that report, resources for site evaluation. Water is one of the major considerations when establishing a dairy. A sustainable, clean source of water is very important. There's no clear indication in the feasibility study on the source of water. You would agree with that comment?
Chair, I do not agree, because we have a license from Water Affairs for access to water, which was issued by the Department of Water Affairs. So the problem he might have had, he only focused the documents that he was provided with were 3 documents without any other supplementary information. And he never came back to the department to say, but I don't see anything that will assist you in here. What other information do we have? So, and he has a disclaimer on that in the report to say, this is the only documents that were me by the investigator, because he was not interacting with us. The investigator provided him with these documents, and he had no access to any other documents because they were not asked from us. But we had permission from Water Affairs access water. Hence I say I don't agree with the statement.
You had permission from Water Affairs to access water. That gives me the impression that you are talking about a river or rivers or dams as opposed to depending on the climate as such.
That's correct, Chair.
Were there rivers
that gave access to the dam that was on the farm, and also access to do boreholes on the farm for additional water.
Well, I don't know enough about boreholes, so I don't know whether the position is that as long as you dig deep enough, you will find water, or whether it's only certain areas where you will be able to do boreholes and find water.
Yeah, it depends on the strength of the area, Chair. Some areas, the water availability strength is low. In some areas, the water availability strength is high, depending on the water table, and also depending on the rainfall in the area where you are. And the area that we are talking about had more than enough water.
So you're saying that the area where the farm is such that in terms of the requirements for finding water using boreholes, that you would easily have been able to find water.
That's correct.
That's what you are saying.
Yes.
And that's based on the knowledge of the climate area.
Particular area.
Oh, okay.
And I agree with him when he says water is key in a dairy. You wouldn't start a dairy when you are not happy with the amount of water.
Okay.
Chairman, I noticed that it's just on 1 o'clock. This might be a convenient time to take a lunch break.
Yes, thank you. Let's take the lunch adjournment. We'll resume at 2. We adjourn.
All rise.